when I was working at Stock and Training, I got friendly with a very eminent international maritime arbitrator called Cedric Barclay. He was world famous at that time. And he got along very well with me. One day he invited me for a tea and he says, when you qualify, start on your own. Don't join any of the big English firm, because what will happen is the senior partner will take you for lunch and say, good job, old boy. And every year he would do the same. But because you are not European white, you will remain where you are. And I said, but I wouldn't know anyone. He said, you start, you're good, you'll do it. And he was the one who encouraged me. And my first client, shipping client, which I got, was Mr. Kolokotronis, introduced by Cedric Barclay. And that time, Kolokotronis was a very big Greek ship owner. Shipping industry was mainly based from London. So that's how I got into maritime arbitration. And then in 1982, I started my own firm, Zaiwalla Company. And today, there are 126 reported cases where the law was changed because of my firm's endeavors. And most of them relate to international arbitrations or maritime arbitration. With this introduction, today we are a boutique firm in Chancery Lane. We are even today the only solicitors firm in the 1 square mile district of City of London, started by a solicitor born outside Europe. And that also happens to be an Indian solicitors firm. The first thing I did when I started my firm was to make sure that I kept my Indianness, and I did not anglicize my name. And that was very important to me, because I wanted the Indian footprint to be placed on the globalization of the legal profession. When I started, there were few Indian firms, but not in the city. They were outside in the suburbs, Southall and other areas. They were doing immigration, crime, and small things. But I said, I'm going to keep my Indian name, no anglicizing, and that's how I started. Now, let me say something about international arbitration. Historically, international arbitration started in the 17th century, late 17th century in London. That time, there was a British Empire, and all the trade used to be done through the City of London, through exchanges. For example, maritime, all the vessels were fixed through Baltic Exchange. Then there was a grain and fleet exchange. And when there were disputes between the brokers representing the overseas party. And those disputes used to be resolved by a senior member or a senior broker. And there was extreme honesty. So they would go to the senior broker, say, this is the dispute, and he will give a decision which will be binding. Interestingly, in India, when I started, there was an arbitration, but it was very, very informal. And until the late 70s, there was no obligation on the arbitrators to give reason for the decision. And the reason for this was that the arbitrators were supposed to be extremely commercial men, and they decided what was right and fair, and therefore their decision was final and no reasons were given. In England then came a different procedure called special case procedure, where the arbitrators' findings of facts were the same, but questions of law can be referred to the court by the party. So this is the history of arbitration. It was a very simple arbitration. Sorry, it fell down. It was a very simple arbitration, and the arbitration normally used to take place in the evening. And the most important thing, which is now lost in the modern day arbitration, that the arbitrators who were appointed were commercial men, and they decided on what is right and fair. And there was enormous degree of honesty around. There was no trying to sort of catch each other out. And for example, I remember one of my very early arbitrations I did. Again, the chairman of the tribunal was Cedric Barclay, because most of the maritime arbitration, he was there. And I said, sir, I want to bring an expert. And he looked at me. He said, I am 76. My colleague, Albert Morris, is 82. And my other colleague, Kingsley, is 79, at their age. If you can find an expert on a technical issue with our experience, we will allow you. And finish. That was the answer. So we trusted the arbitrator. And the arbitrations were also very cheap. They were not expensive, because the arbitrators were not full-time arbitrators, and they had the other business. So they were doing it more as a service. Of course, they were charging for that. Now that has changed considerably now. In today's modern arbitration, it has become like a court. And the only risk in those days was well stated that time, like the Bible of the international arbitration book called Russell on Arbitration. Russell on Arbitration is still there, but now it's become modern. And that was the Bible for arbitration law. And the first sentence, opening sentence in the Russell's book was, honest men dread arbitration more than lawsuit. Now, the reason why this was said, because there was no challenge. You could not challenge the arbitrator's decision because the arbitrators were not allowed to give reasons. And the arbitrators were not bound. They were bound to apply the law, but they applied the law as they thought it was fair to do justice. So this is how the things were going on. Now, let me tell you about how I got into arbitration and some of my arbitration cases, which I'm going to share. Today, as an Indian firm, Indian origin firm, although we are a British firm, we are an Indian origin firm, there are so many cases and so many House of Laws decisions where my firm was involved. And I was lucky because as soon as I started in this one small room office, the High Commissioner for India was Dr. Said Mohammed, who was an ex-barrister. He used to be the Advocate General of Kerala and a Minister for State for Law and Justice in Mrs. Gandhi's emergency rule time. And he saw a young Parsi boy with an Indian name. So he called me. And believe it or not, but without any connection in Delhi, he appointed me as the High Commission solicitor. It was all very informal in those days. And I was fortunate because that was the time when India was going through a famine, food famine. And President Johnson of the United States was giving free food under a United States charity scheme called PL 480. That meant that under PL 480, India would get millions of tons of free wheat, but India had to charter ships. And every year, India had to charter 200 to 250 ships. And every ship had a dispute, either demurrage. They used to pick up cargo of grain or other food from United States ports and then lend the cargo at Indian ports. And in various ports in India, small, big, and every port there was a dispute because there was a congestion. And that gave me the opportunity to get into the real arbitration cases. In fact, one of the first shipping case, one of my major success, which brought me into limelight in England, was way back in 1983, 82, 83. Indian government Charter Party was signed as President of India because that's part of the Indian Constitution, that the government enters the contract in the name of President and sued in the name of Union of India. But for some reason, in England, even when there was Indian government was defendant, the defendant was named titularly as President of India. And Indian government always paid the balance of freight and demurrage late for various reasons because we were going through a tremendous foreign exchange crisis in those days. And there was a claim for a ship concerning La Pintada, where the claim was for compound interest, that if a debtor pays the debt late, say after 2 years or 3 years, is a creditor entitled to compound interest. And Lord Denning, the famous Lord Denning, who was a very much an equity judge, he had given a judgment in a case called the Techno Impacts, that if a debtor pays, if the credit debtor pays the date late, then he's obliged to pay compound interest. Now that meant that Indian government would have liability for that year itself for about $5 million because there were so many cases and they would all come running asking for compound interest. Now, I was instructed, and in those days, because of the foreign exchange crisis, it was very difficult to instruct an English barrister without authority from New Delhi, without Ministry of Justice, because it involves payment in foreign exchange. And I appeared before the arbitrator, and the arbitrator said, oh, you have to pay compound interest, that's the law. I challenged the decision. And all the barristers, because I couldn't appear, now of course I can appear, but I couldn't appear in those days as a solicitor in the commercial court in England. And I was looking for a barrister. All of them said this is hopeless, Denning's judgment is correct. And then Tony Blair, who later on became the Prime Minister, has just started practicing as a barrister. And he was with me in the New Orleans arbitration on the other side. And arbitration is another story. And he wanted some work from shipping because he was in the labor law chambers. And I asked, and he said, yes, I will certainly handle this case. And then he said that why not involve my senior also, Derry Irwin, who later on became his Lord Chancellor. And they agreed with me that I was right and Lord Denning was wrong. And the case came up for hearing before Mr. Justice Taunton. This is completely a true story. At 9 o'clock in the morning, Tony Blair as a barrister, as an advocate, phoned me up and he says, Sarosh, my senior Derry wants to speak to you. Please come 1 hour before outside the court, and please bring a representative of the High Commission, a senior representative. So I went there with Mrs. Charawala, the senior, was the legal advisor of the High Commission, and Tony and Derry both told me that this case is hopeless. You can't argue. The Indian government is going to spoil its name and spoil its reputation. I told the High Commission to please ignore the advice of the Queen's Counsel, Derry Irwin, and the Junior Counsel, Tony Blair, and we are going to go in. We went in before Mr. Justice Stoughton, and Blair and Irwin were totally unprepared, and judge was very well prepared, and we won. And the arbitration reward was remitted back to the arbitrator called Bruce Harris. I appeared again, and again, the arbitrator made the same award, saying that he was not convinced by the argument to the contrary. And again, my matter went before Justice Stoughton, because at that time the commercial court in England was quite small, just 2 judges. And he gave us leapfrog. Leapfrog means go appeal straight to the House of Lords, which is equivalent to the Indian Supreme Court. And we won in the Supreme Court 5-0. And that is a reported judgment. If any of you get a chance to look at my book, which I have written, which has been published by HarperCollins, called Honor Bound, Adventures of, you could, all this, yeah.
Good evening. You are not visible.
Got it? Okay, got it. Okay, got it. Okay, so we won the La Pintada case, and that sort of brought the firm into the limelight. And that case also happens to be India's first ever success for any Indian in the House of Lords in the commercial cases. Thereafter, of course, we had many other cases. There was an arbitration concerning a vessel called Nephos 2, where the Naulakhi, a port in Gujarat, was a safe port. And that again, it was successful. And these are all in my book, which I'm just going to show it to you for those you can. That's the thing. Now, now I'm going to give you some example. Now, I'm going to talk about the advantages of arbitration over litigation. Now, when arbitration certainly had an advantage because it was supposed to be quick and speedy. And it also brought into play the commercial expertise and knowledge of the arbitrators. And the second advantage of the arbitration was it was informal. There was no need to have a strict pleading submissions. I remember when I started arbitration in London, we used to just write letters to the arbitrators making submissions and then the documents. But now, of course, it is different. So that was a great advantage of the arbitration. But because the pleadings and all were informal, the cost of the arbitration was very low. And the most important, the object of the arbitration was for the commercial arbitration was for the arbitrators to provide commercial justice. And most important, the arbitration was considered less expensive. Now that brings me to my next approach in life, in a professional life, that lawyers are not expected to lie for a client. Now this is a complete misnomer that you have to win at all costs. And this is what I learned in England, that the lawyers and the judges, they strive to do justice, and the duty to be fair to the opponent is equally important. Now, this, unfortunately, is not so much in India, but I'm sure it will come. And the reason for that might well be because our legal system and our judicial system, quite frankly, is based on the imperialistic model when Britain was as an empire and was ruling India. At that time, there were 3,500 or 4,000 civil servants, white civil servants at the most, ruling over 450 million Indians. And therefore, they had to keep that glamour and pomposity and keep the ordinary Indian at bay, except for the special Indians who we got along with. And that's why they made our legal system very bureaucratic, lengthy, and long pleadings and all that thing. Now, if you look at London, the pleadings are just not more than 10 pages. This week or last week, my firm started a claim against the Bank of England for the Central Bank of Venezuela for return of its gold worth 1.7 billion. And Venezuela, Central Bank of Venezuela is like a Reserve Bank of India, had deposited gold as to keep safe with the Bank of England. Now they want the gold back, and the Bank of England says, I'm not giving it to you because my government does not recognize the regime of President Maduro, allegedly on the allegation it was elected by corruption and vote rigging. That's a different point altogether. But the pleadings in this case for claim of 1.7 billion is only 12 pages. And if I go to a judge with a huge pleading, judge will not look at it and say, tell me what is the issues. I remember I sat as an arbitrator with Harish Salve and Sir Anthony Evans in Bombay for a 2 weeks arbitration. And lawyers used to give us files after files in the evening. I'm sure none of the arbitrators read it. It only increased the lawyers' fees and gave the lawyers the satisfaction that they have done the best for their client. So that is something which is a difference in the arbitration and the procedure in India and England. And this is where India needs to reform its legal system to make it available to all and make it simple. That is important and less expensive. Today in India and even in England now, what happened is, let me come back to England again, history of arbitration. I think this in the early 90s, Margaret Thatcher brought a big bang in the city of London, and the profession became very, very Americanized. The law firms, which are all English, are now mainly controlled by the American United States, and that came the huge, expensive arbitration. And today, the arbitration costs are probably much more than the litigation cost. In fact, I would much prefer to go to the commercial court decided and have the dispute decided by a single judge than to go for international arbitration, which goes on for a long time and there's delay. The other factor which Indians must recognize in arbitration is the delay. We are so used to delay of the court proceedings and and the arbitration proceedings, and we have not addressed ourselves seriously to it. Now that change must come from within the legal profession and not through Parliament or to the government. We should now ourselves decide as practitioners what needs to be done. And I'll give you an example. I was sitting in a very large arbitration concerning a power plant in Bombay, and my co-arbitrator on the hearing was listed about 6 months before, so everybody knew that everybody is going to be there. Harish Salve asked me that he wants to take a day off tomorrow because the Chief Justice of India has asked him to appear before the Supreme Court for some Delhi airport issue to mention something. He said, ask the chairman. The chairman said, sorry, you can't go. If you go, we'll continue without you. He was very, very concerned. It's a true incident, Harish Salve. Ultimately, we had a compromise. Harish said that he will mention the case at 10:30 or 11 and will get over by 11:30, 12. He can be back in Bombay by 3:30. He arranged that, but the chairman said, okay, then we'll sit from 4:30 to 10:30 in the night. And we did that. And we finished the arbitration and we produced the award. Now, this is something which we in India needs to incorporate. I'm going to now talk about something about the students and what they should do. The most important to succeed in the legal profession is to remember that law is for justice and not justice for law. So you must not have the habit of wanting to win every case. Your duty is to do your best for a client. And it's only with integrity and honesty that I believe you get a divine help. People ask me many times, even the English people and the American, oh, you're so clever. And I said, no, I'm not clever. I graduated from Government Law College in Bombay. But I do believe that if you're honest and sincere and you do your best, there is divine guidance. When people come to me, when the clients come to me, very often I don't have an answer. But so long as I'm honest, my intention is to do my best and not to earn big fees. I get ideas, I get support from whatever it is called, instincts or whatever it is. So the first most important thing is to always maintain honesty and integrity, no matter you find your opponents not accepting this principle. And then, of course, the other thing is integrity. When you start your practice, you need clients. How do you get clients? And I tell my team now that when you meet a potential client, you have to keep an eye for a potential client. But when you meet a potential client, keep in mind that you have 2 minutes in which he will make a judgment on you, whether you're worth it. The first, in that within 2 minutes, you must meet the 3 criteria. First, he must like you with your energy. If he doesn't like you, that's the end of the matter. Second, he must trust you. He must say, this person, a man or woman, is trustworthy. And third, that you can deliver. So that is something, and that also comes with integrity. With integrity, you get good energy, people like you, and they keep it on. Now, I'm going to just, before I end, I'm just going to mention 1 or 2 Indian cases which might be of interest, where the supervision of the court was required. This was a case called Indian Oil Corporation versus Coastal Bermuda. Because I was the solicitor for Indian High Commission for many years, until for my sins I acted for Bachchan's in the Bofors case. And the High Commission, when the VP Singh government came in, removed us, quite entitled to, because the new government wants the new people. I had the honor to represent India in many, many cases. Now, in Indian Oil versus Coastal Bermuda, it was a big case involving $18 million claim against Indian Oil concerning purchase of a supply of oil to an American company called Coastal Bermuda. The oil was to be picked up from, I think, Nigeria or something like that. And the arbitration took place before 3 eminent Queen's Counsel of England, commercial Queen's Counsel. And the chairman was Gordon Pollock QC. I was not involved. Mullah solicitors were involved for Indian Oil from Bombay, but they were, and they had appointed Instant Company. The award came, and this is a very interesting case which you might always remember. The award came against Indian Oil. And the Indian Oil was, okay, they lost. But the catch in the tail was that the chairman of the tribunal, Gordon Pollock QC, who sadly is no more, effectively said that Indian Oil's team was legally inept. And if they had argued the case in the right way, the result would have been in Indian Oil's favor. And this is what he said. This is very unusual, but this is the integrity of the English arbitrators. He said, I wish to record my regret that the sellers, Indian Oil, had not at some stage broadened the scope of the case. The document gave rise to a strong indication that the buyers intended to create clear impression in the minds of the seller that if a satisfactory settlement of demurrage claim were made, nothing further would be heard in respect of enormous losses. In the result, I believe the seller had a far stronger case than they allowed themselves to advance. Now, the Indian Oil team, including their general manager, Ramachandran, and they all come to me. They left Instant Company. They had taken 2 Queen's Counsel opinions. They said they can do nothing because this is a final award. They had agreed not to appeal. He said, please help us, Mr. Zaiwalla, because we don't mind the award against us, but because this is what the chairman has said, that the team was incompetent and didn't know law, our heads are going to be chopped off in India. So then I believe that law has to be innovative and you don't apply the law. And I then took the point that not challenging the award, but on a different ground, that the award should be set aside because the English award is party is entitled to convert it into an English judgment and enforce it. And I said, but there's a clear evidence of the arbitrator himself that the decision was not based on the true analysis of the evidence. It would be against the English public policy for the court to give leave to enforce the judgment. And we succeeded. And ultimately the matter was settled. But the judge and his judgment said, and I quote, that finality is a good thing, but justice is better. So this is one of the cases which I wanted to go. The other was a case called, let me just look at it. The other was a case where, believe it or not, but Ashok Sen, probably none of you might remember him, but he was India's law minister under Jawaharlal Nehru, Lal Bahadur Shastri, and Indira Gandhi. And he had appeared for Steel Authority of India against a company called Hind Metals. Now, steel, again, a big thing. And the arbitrator and the arbitration award went against Steel Authority of India. But let me just find it, But it went against the Steel Authority of India, and we challenged the award. And there were transcripts of a hearing place, and it was clear that Ashok Sen did not get along at all, and he was not understood by the the chairman of the tribunal, Mr. Lotopak QC, was an eminent law professor. And there again, the judge said, it is the duty of the arbitrator to come to a correct decision, irrespective of whether he was getting proper assistance or not. So the importance of the arbitration in England is to get the justice correct. There are many, many other cases, but I think I've said enough, and I'll be happy to answer any questions. I see an Indian mind is capable of meeting and challenging any mind. But what we lack is the intellectual discipline, and what we need is a silent courage to show ourselves, not to make too much noise, but get on with the work. It was not easy for me when I started in London, because they were not used to seeing a brown skin appearing in the arbitration circle, which was in those days a very privileged circle, where even a white lawyer couldn't get in unless he came from a right background. But I stood firm and I went on, and I believe the most important thing is to be honest, silent courage, and always be courteous with whoever you do, and be fair to your opponent. So with that, unless the organizers wants me to speak something more, I'll be happy to answer any questions. Hello. Hello.
All those who have any questions can type in the chat boxes, and sir may one by one address all of those questions for the next 15 minutes.
Yes. I can go on, but it's always more interesting to answer questions from practical experience. And remember, please remember that for modern India, all of us were Indians. And I always, even though I'm a British citizen, I'm Indian at heart. And we must aim to put the Indian footprint on the globalization of legal profession. And you all have the opportunity, and the world is open for you.
So we have our first question in the chat box.
Yeah.
What is it? Says, could you shed light on the aspect of discrimination in international markets as touched upon by you in the chapter, My Boys Don't Trust Indians, in your book Honor Bound?
Yes, I'm going to speak about it, because that's something which really affected my life too enormously. It was not easy. The British society is not racist, but it is very classist. And we must appreciate that, because unlike United States, Britain is not a country, United States, which is a country of immigrants. Britain is a country of natives. And they had ruled 2/3 or 3/5 of the world for 300 years. So it's not difficult. It's not easy for them to have accepted somebody coming into their principal field, like international arbitration, which is completely white dominated. This was a chapter which historically has changed the judiciary in England. And I'm going to tell you the story with some interest, because it was not only easy, but there was an inquiry into the conduct of 3 Court of Appeal judges. What had happened was that in the shipping maritime arbitration, the ship owner legal fees insurance cover, and that is a specialist insurance group called P&I Club, Professional and Indemnity Club. Now, whenever a Greek ship owner or any ship owner wanted to instruct my firm, the P&I clubs, the 4 or 5 in England, they had a monopoly and they're very powerful. They would just give a smile and not reply. So I was in Bombay and I told the Great Eastern Shipping, Kanubai Seth was fortunately still there. And I said, look, why don't you instruct my firm? We've got a track record. He says, Sarosh, whenever I mention your name, there's the Britannia P&I Club, they make faces. And they said, no. Second time I went to him, he said the same face every time. And he said, go and meet the chairman. I met Chairman Mr. Patterson. He would smile at me. He said, yeah, we'll consider. Then, as it happened, Ravi Ruya of HR had come to me for some private dispute, some urgent private dispute he has with some other Indian in England, and I had resolved it from him imminently. So he was very pleased. So when I went to see him in Bombay, I told him, I said, Ravi, you're happy with me? Why don't you ask SR Shipping to instruct me? So a typical Indian style, where the big boss takes a decision, he put up his phone and told Captain Kumar, who was his head of his shipping department, to appoint me as their solicitor. So I went to meet Captain. He said, go and meet Captain Kumar in the same. And he appointed us. But their club was Britannia P&I Club, and 2 ships concerning the vessel called Nun Ekta. So, and Captain Kumar phoned me next week. He said, "Oh, there's a problem. The club doesn't want to appoint you." I don't know why, but they said no. He's not in our approved list. Actually, because Kavi Roya has said appoint me, the Captain Kumar in the typical Indian boss fashion said, "No, my boss has said I must appoint." So they sent a representative to Bombay to meet Captain Kumar and try and dissuade them from appointing my firm. Ultimately, this went on, and I continued to act. Then they even took an advice on their own from a counsel and said, "This case is hopeless, stop this case." And then the case went to arbitration. And 2 days before the arbitration hearing, the other side gave in and we won. And I went to see Mr. Patterson. I'd gone to see him before. And he says, "Sarosh, I have no personal problem with you, but my boys don't trust Indians." Openly. He has never denied that he said that. Now, in those days, fortunately, I was very close to John Major, and that's another story in my book, who was the Prime Minister. And I was on the One Nation Forum as a committee member. So I took it up with the local MP, and we decided, and with the John Major's written letter supporting that he will not tolerate racial discrimination, I complained to the Commission for Racial Equality. And the Commission for Racial Equality started proceedings against the Britannia P&I Club. Hue and cry. They brought 2 arbitrators who said it was, then the defense was that it was not Indian race, but Indian style. And I said, "Look, I have not practiced in India. I have trained in an English firm. So what is my style?" So they brought various evidence and all that thing. Ultimately, there was a case again called a Spanish ship owner had come to me, Flatamintos, which is also a reported case. I appeared before the arbitrators. 2 of them had given evidence against me that my Indian style was different and was not suited for English arbitrations. And they made an order, which is quite unusual. So I applied to set aside the order. And I wanted a German because they managed to get in England, it was possible to get a hearing within 2 days. So they got the hearing, but my clients were in Spain. It's a very big Spanish group for Flatamintos. And I appeared before Mr. Justice Morrison for adjournment. He said, "Mr. Zaiwalla, everybody knows you. You can do it yourself for 2 days hearing." So it was before him. The other side had a QC called Schaff. And at the end of the hearing, the judge said, "There's something odd into it. What is the real reason?" And I said that Mr. Harris was giving evidence against me in the race relations proceedings. That blew his top, and we won. But he gave a very nice homily to the arbitrators. If I can read it out, why it's important to get. If I can find go on to support lawyers from other jurisdiction, because most of the work comes from jurisdiction. Then they issued contempt proceedings against me, threatening to send me to jail for revealing what had happened in the arbitration. I didn't give in. The matter went for the contempt. In the last, Mr. Justice Morrison gave me a letter saying this was not a contempt, and they withdrew. Matter was closed after that, and I had gone to Commonwealth Law Conference as part of the British team, and there was a resolution. This is how to do it without shouting and screaming. There was a resolution to condemn the Malaysian government, or criticize the Malaysian government for its trying to pressurize the bar in the judicial profession. I told Lord Justice Wolf, was the Lord Chief Justice, that I am going to say that this also happens in England. He was quite red. And I was on the panel with him at this event. And we had a deal. He said, "Look, I'll call you for a cup of tea, we'll chat. I know your case, what you had complained about, and we will sort it out." I agree. Now, after this had happened, in the Flatamintos case, the judge made some observations about my Indian style, which is also a reported judgment. As a result, without my knowledge, the CRE decided to withdraw the complaint. And that was a very, very, the case. So I made an official complaint against the Three Court of Appeal judge. That requires silent courage. Three Court of Appeal judges to the Lord Chancellor, who, if you recall, was the same man who had appeared in the La Pintada case as a leader. He was Tony Blair's Lord Chancellor. And I wrote to the Prime Minister, Tony Blair. And Derry Irwin, the Lord Chancellor, started an official inquiry into the conduct of Three Court of Appeal judges. Now, I was going to mention that in the Malaysian thing. So when I met him, when I met the Lord Chief Justice in his office, he invited me for a cup of tea. Again, calmly, not complaining, not arrogant at all, very smiling thing. He said, look, Mr. Zaiwalla, you have made your point. We will reform the judiciary. I said, look, there's not a single judge in the High Court. The QCs were there, but they were never just a nominate. No, there were no QCs also. And he promised me, he said, you withdraw your complaint, because this was the first time in the 300 years history of English judiciary that the Lord Chancellor had started an official inquiry into the conduct of Free Court of Appeal judges. And this had caused so much concern that Mr. Justice Morrison, who was for me, he actually came to meet me privately and said, Sarosh, please don't withdraw your complaint. Half the judges are for you, half the judges are against you. And the issue for or against was whether the Lord Chancellor had the jurisdiction to inquire into the conduct in court of the judges. Ultimately, I withdrew, and Lord Chief Justice Wolf kept his word. And since then, we have a judges. Since then, the whole profession has changed. So there was discrimination, not from all, but from few. This chapter, My Boys Don't Trust Indian, is approved by the present Lord Chief Justice in writing, Lord Justice Wolf, the former Chief Justice. And in that case, I've also dealt with the case of Kamlesh Bahal. Kamlesh was a Gujarati East African lady, slightly arrogant. She was appointed by John Major, the chairman of the Equal Opportunities Commission. Very bright. I remember I had invited her for lunch and she said she had no time to meet me. She became the vice, on a merit, she was elected the vice president of the Law Society. Now, by convention, the vice president becomes the president and is knighted. Now, in Kamlesh's case, 6 or 8 weeks before she would have become the president of the Law Society, the then president, Sayers, started an inquiry from a complaint by one of the employees that she had bullied the employee. And quickly everything happened, and Lord Bridge was appointed the inquiry chairman, and within 8 days found that Kamlesh Bahal had bullied, and she was sacked as the vice. Now this quite an event. Kamlesh fought it out. The case in the race relation ultimately lost, and they wanted a huge cost. At that time, Kamlesh came to me, and I had just taken on the position as the chairman of an organization for people of Indian origin. And with Lord Dolakia and other Asian lords, we had a meeting in the House of Lords committee room. And we gave a call that the Law Society does not change its policy. We will start an Asian Law Society. And that, in fact, changed. Now, in this book, My Boys Don't Trust Indian, you will see this chapter also. And I can confirm that I have, the Law Society has approved the draft of the chapter which I sent them with certain corrections which I had incorporated. So the position is this, that in England now, the situation the last 20 years, this is the story which I gave you was 20, 25 years ago. Now it's completely changed. And I think, look at it now. Today, I could not have imagined 25 years ago or 35 years ago or 40 years ago when I started that there would be an Indian cabinet minister. And today we have 4 cabinet ministers. Today, the Attorney General is a young lady of 36 years. She's a Goanese from Kenya. Her surname is Braverman, but her original surname is Fernandez. And the Chancellor of the Exchequer, the whole thing has changed. So not to worry about racism. But when you come to England to learn or to practice, you must accept the culture. There's still tremendous integrity and honesty in the legal profession. And if a lawyer lies or is found lying, he can be seriously punished. I hope that's a good answer. But you must read this chapter, My Boys Don't Trust Indian. In it, there's a photograph of the letter from the Prime Minister, letter from Tony Blair. In this, Tony Blair says, many thanks for letter of 27 January 1998. Enclosing one you sent to Derry Irwin. I know Derry will take a long day on a Prime Minister's note paper, Tony Blair. And the Prime Minister says, 15 June 93, racism is something I simply will not tolerate. I do very much believe that the state of the race relations in Britain today is generally better than any time in the recent history. I am keen to play some small part in harmony. So we have worked, all of us work to make the society open. And I said that an Indian mind can change any other mind and can be better. But what we require is intellectual honesty and intellectual discipline. Next question, if there is.
So a lot of students want to know what your advice will be for students in law college right now if they want to pursue international arbitration ahead. So what are the skills that they develop while they're in college?
Well, the skills you really develop is by practice. And in a college, you can only get the bookish knowledge of what the Law Arbitration Act is, because the Arbitration Act is an evolving process. And the thing to do, the first thing they should do when they qualify as an advocate is to join a law firm or a lawyer who has an arbitration practice. And I was lucky that I joined Stockton and Company, which used to do maritime arbitrations. And therefore I got into the arbitration just by chance. I never planned to go into arbitration, but then that's what happens. So they have to join and the thing. And if they want to become a specialist arbitration, they must learn and read the authorities. One of the reasons which I attribute my so-called success is that traveling from my home in the suburbs in England, underground train was about 45 to 45 minutes to 1 hour journey. I used to read every judgment of the Lloyd's Law Report and Weekly Law Report, whether maritime or not, just out of interest, out of curiosity. And that today, when I look back, that gave me the knowledge of all aspects of law. And so you read the law, read the case law, and just work hard. Next.
How did the solicitor's exam shape your career? And would you advise students to keep on trying to give it and study for it?
I think a solicitor's exam gives you a career because it allows you to be in direct contact with the client. I'm talking about England. And you can actually, if you have a good personality and you're a likable person, you can market yourself, but market yourself in a subtle way. Because if you tell a person, a client, potential client, I am good, he's going to say I'm crazy. So you have to market yourself in such a way by your track record or by your pleasantness and the intelligence which you display in conversation. So I think it doesn't matter now whether you're a solicitor or barrister. In England, the distinction is practically gone. When I started to become a solicitor, I was not allowed to appear in court. Today, I can appear in court. The judge would immediately said, yes, you can appear. And that happened in the Flatomintos case 25 years ago. So there's not much difference between a solicitor and an advocate or a barrister.
So, do you think allowing foreign lawyers to practice in India will be detrimental in the Indian paradigm?
Certainly not. This is a very, very interesting question. And I have spoken out quite violently in respect of this question. If the foreign law firm comes, those who will benefit are lawyers, young up-and-coming lawyers. But at the moment, this is the honest answer. I know my peers in India will not like it, and I've said openly that the quality legal work is monopolized by 9 or 10 firms. And these 9 or 10 firms would not like any competition from the foreign lawyers for the quality work. I believe that if the foreign law firm comes in, it will give opportunities for young Indian to join the foreign law firms here and become a partner. When China, years ago, when 91, when I lost the Indian High Commission account because of acting for Bofors and Bachchan, Amitabh and Ajita Bachchan, the China picked me up and I started an office in China with the support of Chinese government. And my advice to them was that please open up to the foreign law firm, but make it absolutely essential that 50% of the partnership should be Chinese and they should learn. And today, Chinese lawyers are competing with the top international law firm. Whereas India, we're just stuck with 9 or 10 famous law firms who monopolize all the quality work. In fact, one of those law firms, I know all of them, but one of them told me quite honestly that we don't want, because if our monopoly is gone, the big money is gone. And I think we should welcome, because with that, more inward investment come. And the reason I say this, that if I am investing in, say, if I'm a British Englishman and I'm investing in India, not me personally, but why should I not have my a law firm which knows my culture representing me? And why should I trust Indian law firms, however good the reputation, whom I have not met before, and I don't know them? And that is a hindrance to foreign direct investment. So if I was advising, I've advised it in the past, but nobody has listened, I would open up the Indian legal profession to foreign investment, to opening an offices here. And that will give enormous opportunity for young Indians who do not have contacts, because the foreign law firms works on merit, not on whom you know or not on patronage, which patronage unfortunately is part of the Indian system. So it will be very good for the young Indian lawyers, and we must all work for India's sake to open a profession. Today in China, I had an office in China for many years. The investment is coming in because there are international law firms and Chinese law firm competing with the international standard. And it will also bring the cost down, because today I understand that the Indian law firms who have this monopoly, 9 or 10 law firms, charge enormous fees. So I would certainly say yes, and not to be emotional about it. It will be benefit for our young Indian lawyers. Next question.
So would you say it is important to get an LLM in international arbitration to be able to further your career in that field?
The honest answer is no. LLM is a nice degree, like a PhD to show, but I consider myself a foot soldier in the field of international arbitration. And I don't think it matters anything at all whether you're LLM or not, because in the legal profession, you learn on the track. As you're working, you learn. What counts is the experience, and not, we learn, for example, when I passed government law college in those days, the law education is not what it is today. We were just given lectures, there was no other training, but we worked our way up. And in practical terms, what happens is that you can have any degrees you want, but at the end, you learn on the job. It's a profession. And like any other profession, you join a senior, you learn on the job. So the choice is to select a good senior. So the answer is no, not necessary, but you can always have it if you feel it's a glamorous. Any other question? I can read a question.
Yes.
What is the question?
So we would like to know if those who are interested in international arbitration, what kind of reading would you suggest? Any judgments that we must know and should go through in order to work in that?
The two practicing books are, which you must keep it with you, is Mustil and Boyd on arbitration, the latest edition. But that's good. And secondly, the historical Bible of our international arbitration, of course, is modern now, written by James Son. Now the editor is a new editor, Russell on arbitration. And then you keep track of judgments, not only Indian judgments, but also English judgments, because the English judgments are much shorter and much better reasoned. And that is what is also important to know. We want to bring in India also this practice of shorter judgment and trying to do justice and not technical law. And this is the trait of the English Commercial Code. Today, the English Commercial Code is considered the international commercial code. 3 years ago, I had a case for Mongolian government-owned company called Erdenet. They're the second biggest copper mine personally against Kazakhstan government and the president of Kazakhstan, because the Erdenet had supplied some copper ore to a company in Kazakhstan, government company that was privatized, and by the son-in-law of the late son-in-law of the president, and they never got the money back. Now there was no jurisdiction. They called me to Mongolia. Mr. Sagan was the chancellor or the finance minister when I first met him, and he was the chief of cabinet. And he said, "We have a very difficult case. Everybody has said you can't do anything." It was about 17 years old case. The defendant company was liquidated after privatization, and what do I do? But they were very upset, Mongolians. So they called me, said, "Can you solve it?" Next day, I met with the Erdenet team, and I found that there was a diplomatic meeting between the president of Mongolia and the president of Kazakhstan in Ulaanbaatar. And this case was raised, and the Kazakhstan president said, if we can't solve it, we will have it resolved by international court. I took the chance, so why don't start proceedings in England against the president of Kazakhstan personally. And on the basis that the English Commercial Code is considered as an international code. And we got leave to serve. Then the Kazakhstan government challenged it, we lost. We got leave from the Court of Appeal. And believe it or not, 2 days before the appeal hearing, the Kazakhstan government paid the money to a third party. So and what I'm trying to say is the English court is considered a commercial court because it tries to do justice. Law is there, but most important is within the frame of law, apply the law in such a way that a commercial fair justice is done. And this is the right thing about it. And I have tremendous regard for English court. And the way, as I said, we are suing, and it's quite an honor that an Indian firm, the Venezuelan government had come to me to take Bank of England. Last year, we had a case for Iran Bank, Bank Malat, which is internationally famous case, which they lost in court, commercial court. Stephenson Harwood were acting. And then we took on and we won in the Supreme Court before 9 judges. And the Supreme Court declared that the UK government had acted unlawfully and irrationally in listing Bank Malat, my client, for supporting Iran's nuclear proliferation. And we had a claim for $1.6 billion. And ultimately it was settled a day before the trial. So, and I don't have LLM degree, we just do our best. And most important, mind that possess a pure, kind, and radiant heart, and always remember prayers. And this is my personal experience when I get cases, and I've never been ordered about monies or fees. Of course, fees come, it is necessary, and God provides. But always pray. Be sincere that you want an answer. And if you want an answer, instinctively, you get an answer. Now, when the Venezuelan came to me, I think 3 months ago, it looked hopeless to take the Bank of England. But the answers came. And I said, people think I'm very clever, but I'm not. You just pray and you get the answer. It comes instinct-wise. But honesty and integrity is most important. Keep an honest heart and be fair to your opponent. Next.
So what are ways Indian students can gain experience in foreign law firms? And how should students go about earning a training contract from law firms?
I'll answer the training contract first. Training contract is difficult because my firm used to have 2 training contracts available, but we stopped it because the Solicitors Regulation Authority has made it very cumbersome now for training contracts, the responsibility of the supervising solicitors. So the first thing they must do is to get an expert to write a CV, a specialist to write their CV and apply to the firm. There are many training contracts available. We have only one, but which has been booked for the next 5 years. And get a correct CV. If the CV is good, then you will be invited for interview. But if your CV is not correct, it will not happen. What was the second question? How to get internship and how to survive. Internships are easy to get. Firm always has interned mostly from India, China, Hong Kong, everywhere for a week or 2 weeks. We give a nominal £100 a week, but we give a training for 2 weeks and we give a certificate, which helps them to get a CV, have a better CV, and they can either then get good pupillage from a good chambers as a barrister or a law firm for training contract.
So a lot of students from GLC are attending this webinar, and one would like to know your experience in GLC because most of us have shared the same college and circumstances.
My best experience, because as I've said in my book, when I was a kid in India, I wanted to be the Prime Minister of India. And we were so anxious. I was on the committee of I think AICC, because that was the only party. Then I used to attend all these political meetings. And we formed the first ever student union in GLC. And we had the college shut down for a day. And I was lucky that we had some very good lot of clever students. One of my colleagues was Maruzman Patrawala, who went on to become a minister, and he passed away. The other was Firoz Talia Khan. His father was the minister before. And so we had a very active group, and it was great fun. But we also had a very good, kind principal called Takia Tope. I started canteen as a student cooperative. We used to run a canteen ourselves, but it was fun. And that also helps you to build your, it was a great experience, but it was a different law college. We had a morning law college from 7 to 10 or something like that. There were only lectures, there were no discussions, and that's it. We had to study on our own. There was no practical experience at all. Then it was 71, there was a general election, and I was the general secretary of the Students' Union. And I had a program inviting leaders of all political parties at the government law college and to give a lecture on what my party stands for. And I remember we had a very high quality people, and one of them was George Fernandez, whom I met many years later when I was invited for an event in the British High Commission. He was there, and he remembered that I'd come to government law college, and yes, you invited me. So it was a fun year, but we have to, in student days, make it fun and responsible and make it as a learning experience. Enjoy also, have fun, not to just look for future, but have a balance.
So where do you think international arbitration is heading, and how will it evolve in the years to come? And what are the problems nations are facing?
I think international arbitration, I don't see continuous bright future for international arbitration now. The reason is this, that it has become too much court-like, and at least in court you get a 100% fair final judgment, subject to appeals, of course. But the international arbitrations are now so long drawn out and so expensive. I think what we are going to go for is mediation. Now, I had this claim of 1.6 billion on the trial was starting on 15th of June 2019, and we were very worried because 23 Iranians were giving evidence against a powerful British government team claiming damages from Her Majesty the Crown. And I wanted the case settled, and we tried to settle, but the British government said, no, you're going to give, we're not going to pay you anything at all, go away. Although we had won in the Supreme Court. And I applied to the court for mediation, and they came up with the Queen's Counsel, Mr. Fonto, and they said, no, we don't have time, we are busy with Brexit and all the thing to go into mediation. And a judge ordered mediation. And it went on for a week, but we settled it. And we got an 8-figure amount in settlement. So I think we are not going to see the international arbitration going the same way unless the participants are realistic to keep the cost down, make it quicker, and make it more commercial and the more fair judgments, and not very legalistic. And remember, in international arbitration, the quality of the arbitrators is also very important. I was representing India in the International Court of Arbitration of the ICC, Paris, International Chamber of Commerce. And I remember 2 Indian, one of them eminent partner of a big Bombay firm, approached me and said, I want to appoint you as an arbitrator. It's a difficult case, but you must give a dissenting award. And I said, certainly not. And I got another, again from an Indian lawyer, and who is now eminent, saying that we'll appoint you, but you don't give an award against me, against our client. Now that is also important. So we must make sure that we must eliminate any arbitrators who could be bent. And this is done not by the parliamentary law or by the government. In England, the way it is, any arbitrator is found that he is crooked or bent, he will not be appointed. Nobody will invite him. And that's the way to do. And it's up to the young generation to ensure that the honesty is there. I remember years ago when I was your age, just qualified, I just started my firm and I went to Delhi, and Chief Justice Pathak was the Chief Justice of India. And I went to see him and I asked him, but I'm hearing now that there is some corruption in the lower courts in India, judges. And he referred me to a book by Lord Denning in his autobiography. He says in the preface that 300 or 400 years ago, the Lord Chancellor of England conducted an inquiry on the issue of corruption in the English judges. And out of 25 judges, 24 were found corrupt. And for the part, what Chief Justice Pathak told me, but there was that one judge who was not corrupt. And because of his firmness in not becoming corrupt, ultimately his profession changed, judiciary changed. And we need to do the same. So to answer your question is that international arbitration at its height just now, but it will not remain at its peak unless steps are taken to ensure high quality of arbitrators, speed, and competence of the arbitrators, speed, and less expensive. Next. I'm being very honest, no, open.
So what do you think will be the prospects or like the future of online dispute resolution, and how do you think will technology change the rules of arbitration?
I think that's the most interesting question, and which is agitating the minds of all of us. And there's a lockdown now, so I'm at my house in the country. The weekend I came, that Monday, we had a hearing in one of the Venezuelan case again, and we had an online hearing. Not very satisfactory, but now it's becoming the norm, and I think it's working out quite well. And we will soon see that everything will be online. Majority of the cases will be online, because now I find that not traveling and staying at home, we are working very well. So there is going to be online arbitration, and there is going to be online. It is going now full swing in England. We had to file a case yesterday or day before we filed against the Bank of England. It will come in the news report tomorrow or this week, because today I'm told the United Nations Secretary General has allowed a discussion in the Security Council on Venezuela. So the online is going to go on, and I wouldn't be surprised if the new system will not be like the office. There'll be few offices, people working from home, and the system is being evolved. Next. Anyway, at present, we don't have choice but to have online.
So I think we've addressed most questions.
Excellent.
Yeah.
So thank you for inviting me.
Sir, on behalf of Burnished Law Journal and the Government Law College Alumni Association, I would like to thank you for sparing this time and guiding us on this important topic. We would appreciate if you could share your email ID, so students can write up any questions they may have later.
I send you my personal secretary's email ID, because I get so many of this question, so many emails, and she will sort of filter it and send them to me. So how do I send the email ID?
So you can just say it right now. I will write it.
Okay, it is all lowercase. S for sugar, AROSH dot Zaiwalla, ZAIWALLA at zaiwalla.co.uk. But more important, Emily Simmons' ID, because she looks at it first. E capital, M for mother, I for India, L for London, Y for yacht, Emily dot Simmons, S for sugar, I for India, M for mother, O for orange, N for nobody, S for sugar, Emily.Simmons at lowercase Zaiwalla, ZAIWALLA.co.uk. I repeat, E capital MILY dot S capital IMONS at Zaiwalla, all lowercase, Zaiwalla, double L, Zaiwalla.co.uk. Thank you.
Thank you so much, sir, for your valuable speech, your experience, sharing your experience, and thanks to Government Law College Mumbai, Anushka, everyone for coordinating us, joining us. Thanks, everyone. And those who are interested in paper publication, you can visit our website, burnishedlawjournal.in. You can send me your paper on our email ID, burnishedlawjournal@gmail.com. Have a nice day.
Congratulations to Burnished Law Journal. I should have mentioned it for organizing it. It was great fun. And,
yes, sir.
My best wishes to you and everybody, all Indian up-and-coming lawyers.
Thank you so much, sir. Thanks a lot.
Thank you.
Bye.